How we doing, everybody? Dr. Stringer back. We're on to Module 3 this week. So we're talking a little bit about historical and contemporary perspectives on courts. That is at least the title of this module and this chapter. A lot of this is more related to kind of a review of law and how the courts would deal with that law, as you'll kind of see. So we're not going to get too much into the history of actual courts, more so the history of the evolution of law and how the courts have been working with the law. So probably not as long of a video as we had last week, and hopefully a lot of this will be a lot of kind of review material from your 1101 class, kind of similar to what you had last week. So after this week and probably next week, we're going to get into probably what's going to be a lot more new material to you all. So looking at, where law came from, those of you have probably heard of something called common law, and kind of this code of Hammurabi and the eye for an eye, and things like that. And so under common law, which originated in England, the crown would just kind of decide what you did was a crime or not, and there wasn't really any statutes or laws on the books, so to speak, that you would think of today, and so this was rather problematic because you're actually creating law after the fact and saying, okay, well, you did this act, now I'm going to say that this is actually an illegal act, and then punish you for it without it actually being on the books. And in that sense, it was kind of retroactive. And so that's one of the things which actually our Constitution forbids now, probably as a result of that. Actually, I'm quite sure as a result of that, to say that laws cannot be retroactive. So, for instance, if we decided to outlaw alcohol in the city of Kennesaw or the state of Georgia and suddenly passed a law that said that alcohol was illegal, we couldn't then go and arrest everybody that had possessed alcohol before we passed that law. We could only enforce that law after the law was on the books. But under common law, you could not necessarily have that case. And so the Latin term for this is post ex facto. So if you see in constitutional law, you'll see issues of post ex facto laws and how they can't be enforced. And so one of the things that's kind of interesting nowadays is, with post ex facto laws is in states like, Colorado and Washington and places where people are in prison for possession of marijuana or in jail or whatever, but now marijuana is legal there. And so they're all like, well, I want to get out, and I should be released. And so the big deal with that, it goes back to this post ex facto deal that they were convicted back when the law was on the books, and so the law can't be retroactive. It can't say, well, now we're going to put this law on the books and then it can go and apply to things that happened before the law was on the books. It doesn't work that way. So unfortunately, there's a lot of probably very mad people in prisons, in the jails in those states and other states too. So moving forward from there, there's also a doctrine known as stare decisis. And this is very much relevant to courts because it involves precedent. And I talked to you guys a little bit about precedent last week when we were talking about the idea that the opinions that are set forth by the U.S. Supreme Court are binding on all of the lower courts. And we talked about how the opinions from the Georgia appellate courts are binding on all of the lower courts, meaning that they have to follow these decisions, these past decisions. So, for example, in 1963, the United States Supreme Court passed the case of Miranda versus Arizona, which, for those of you that don't know, said that whenever you're interrogating someone and they're in custody, then you have to read them their Miranda rights. You have the right to remain silent, your right to an attorney, your right to all of these things. If you can't afford one will be appointed, yada yada yada. And so then, after this was passed this decision was handed down by the United States Supreme Court, every police officer in the entire country had to do that if they wanted to conduct custodial interrogations. And so there was actually later, and there was a case called Dickerson versus the U.S. Where the federal government had passed a law that said that you didn't have to do that. You didn't have to read people their rights anymore. I believe it's around 2012, if I'm not mistaken. And this was obviously went to the Supreme Court, and the Supreme Court said, no, you do not have the authority to overturn our ruling. It is a ruling based on the Constitution. As the Constitution is the supreme law of the land, you as the legislature cannot overturn that. The Supreme Court themselves could overturn it if they wanted to, but they chose not to. So these are all things to think about. So whenever, if you're going to trial for some issue, maybe, I don't know, say you're going to trial, and we'll use the Miranda versus Arizona decision. Suppose you're going to trial and you were interrogated without having read your rights. Well, your attorney would probably make the argument that you were interrogated without having read your rights, and that evidence should be excluded. And so you would bring in that case of Miranda versus Arizona, although Miranda versus Arizona is very popular, so you might not have to tell the judge about it, but there would be tons and tons of other case law that you could use with literally a plethora of other issues that you could then use to set precedent and say, look, the Georgia Court of Appeals, or the Georgia Supreme Court, or if you're in federal court, the circuit, the Ninth Circuit has said this, and I told you guys how rulings from the Georgia Supreme Court or the Georgia Courts of Appeals are only binding, so to speak, on those courts within their jurisdiction in Georgia. And the same with the deal with the circuits in the federal system. What's passed by the circuit court in the Ninth system is not binding on the Fifth Circuit, and so forth. So, in some instances, judges may not follow precedent if they're in a situation where they don't have to be binded by it. And this might be the case with the Supreme Court. And so one of the big examples of this would be that the U.S. Supreme Court can overturn its previous decisions. And a big example of that is Brown versus Board of Education. And so when they passed Brown versus Board of Education, they overturned Plessy versus Ferguson. And for those of you that don't know, Plessy versus Ferguson, which was the Supreme Court case that was much earlier, that preceded Brown versus Board of Education, and said that that it was okay to have segregation because things were separate but equal. And so then that was precedent for a while, up until the U.S. Supreme Court found and opined, or whatever, if you will, created the opinion in Brown versus Board of Education, and then they said, no, separate but equal is not acceptable. We're going to say that you should integrate the schools here, and so you are not allowed to have separate schools and separate bathrooms and all of these other things. We're overturning that. And so, this would apply to the Supreme Court. They can overturn their own decisions. The Georgia Supreme Court or the Georgia Court of Appeals could overturn one of their decisions if they wanted to. The one thing you can't do is you can't overrule a decision that's made by a court higher than you. So, for example, the Court of Appeals in the state of Georgia could not overturn a decision that is made by the Georgia Supreme Court. And similarly, the Georgia Supreme Court could not overturn a decision by the U.S. Supreme Court because the U.S. Supreme Court is the highest court in the land, and no one gets to overturn them except for themselves. Going back up a little bit. So there's three main sources of contemporary sources of law. They are the Constitution, there's legislation, and then there's administrative regulations. So we've already talked about the Constitution a little bit, and I'll go into some more detail about that. And then there's legislation. So there's legislation is just your general laws that are passed by the federal and state government, such as your law that, your name any law. Or we just talked about the law of, marijuana legalization in some states. So these are just your general statutes, that's illegal. Kennesaw has a law that you have to own a gun and keep a gun in your house if you live in the city of Kennesaw. Administrative regulations are a little bit different. We're not going to go into a whole lot of detail regarding them. The big example that I like to use is for the Department of Motor Vehicles in some states, such as, I believe it's called the Department of Driver Services in Georgia. But they would actually be able to create their own regulations which regulate driver's licenses and maybe when your driver's license is suspended and things like that. And then there's other entities, smaller administrative bodies that have the same ability to create regulations, so to speak. But they're not too big for us. So looking at constitutional law, big ones for us in criminal justice and criminology are the Bill of Rights. So for those of you that don't know, the Bill of Rights gives us a bunch of rights as citizens. So the First Amendment, which you're probably familiar with many of these, is your freedom of speech. The second is your right to keep and bear arms. The fourth involves search and seizure and things like that. And the Fifth Amendment, gives you several rights, such as, your right to, grand jury, double jeopardy, self-incrimination, things like that. Also, under double jeopardy, a thing to think about too is this idea of dual sovereignty. Because we consider the federal and the state governments to be separate sovereigns, you can actually be tried for the same offense in federal and state court, which some people might think, well, that violates double jeopardy, but it doesn't, because you're not in the same court twice. So if you committed an offense that was an offense under both federal and state law, you could theoretically go to prison and be tried under both federal law and under state law. What will probably happen is if the federal government wants you, they will get you. There's been several instances where the state has had someone and they wanted to prosecute them, and then the federal government has decided that they wanted to prosecute them. They issued a warrant for the person. The FBI came and got them from the state jail, the state prison, and then they were taken off to federal jail or federal prison to stand trial there. And that's because federal law trumps state law, and so the federal government has a lot more power. The other one under the Fifth Amendment is your self-incrimination, which you guys have probably heard of before, so I won't go into too much detail there. Your Sixth Amendment, you've got a lot of rights when it comes to trial, which is kind of important for us since we're talking about courts, which is your speedy trial, your right to a public trial, impartial jury, to be notified of your charges against you, to be represented by counsel, your rights to confront witnesses, and all this kind of stuff. We're going to go into more detail about this as we get through the different modes of trial. We'll talk more about all of these things. Then your Eighth Amendment is just kind of bars state action, such as excessive bail. One thing to think about with excessive bail, you don't have a right to bail, you just have a right against excessive bail. So it would probably be excessive to say that we're going to give you a $1 million bond or bail for being arrested for possession of marijuana. But if they wanted to, they could just hold you without bail, and you have no right, or no, there's nothing you can do about that. So they can just say, well, we're denying you bail. And so an interesting thing is actually happening with drunk driving in a lot of states. People are being denied bail for drunk driving offenses, which are misdemeanors. And so, you would probably consider it to be excessive if we gave someone $1 million bail for a misdemeanor offense, and then if they did that, then you might be able to make that argument, this is excessive bail and it violates the 8th Amendment. But if you just deny people bail, then, well, you can keep them in the jail, and there's absolutely nothing you can do about it, even though, there's some people that would say that involves being punished before the fact, but that's not necessarily the way the law looks at it. So going on with punishment, your 8th Amendment also prevents cruel and unusual punishment. So some of you have probably heard about, issues with the death penalty and cruel and unusual punishment. It was actually ruled unconstitutional some time ago, and then, they changed their mind and decided that it was not cruel and unusual anymore. And now, currently, the opinion is that the death penalty is certainly unusual, but it is not cruel. And so, moving on, there's a few more amendments. The 9th and the 10th are not particularly important for us, but they are part of the Bill of Rights. And the 9th just says that the rights listed in the Bill of Rights are not exclusive, that you can't have other rights that are not there. And so that leaves a little bit of leeway for the Supreme Court to be able to say, well, this wasn't enumerated in the Bill of Rights, but we think that you still have the right to enjoy peace and happiness or something like that if the Supreme Court wanted to say that, which they haven't. But anyway. And then the 10th Amendment says that all powers not given to the federal government expressly are reserved for the states and the citizens. Because remember, back when the Bill of Rights was passed, they were really trying to enumerate all of these rights to prevent the federal government from having so much power and being able to overtake everybody, even though that's kind of, the way things work anyway. But it's still better than it was under the Crown in England, and so there still are a lot of rights that we have that they didn't. And so with that said, like I said, most of these amendments were just meant to apply to the federal government. And so for a long time, you just had rights against cruel and unusual punishment and rights to attorneys and rights against self-incrimination, and all of these things were only applied to federal prosecutions. And for those of you that have taken criminal procedure, you probably already know all this, or constitutional law, that under the 14th Amendment, the Supreme Court has slowly over time, this began back in the 60s, well, actually a little bit sooner than that, most of it began in the 60s. They started to incorporate some of these laws or some of these constitutional rights into state prosecutions and state courts. And this is known as selective incorporation, because not all rights have been transferred onto states. And so you have a right against self-incrimination and all of these other things, these things that they consider to be fundamental rights. And the way that they do this is through the due process and equal protection clauses of the 14th Amendment, which says that states have to, abide by due process and equal protection. So those other amendments that we've talked about that are related to due process and equal protection and being considered fundamental rights that are to be enjoyed by everybody, regardless of whether it's a federal or state prosecution, have actually been interpreted to apply to the states through the 14th Amendment, which is, I think, an interesting thing. You might not find it as interesting as I do. So getting away from the constitutional law, the substantive criminal law is perhaps a little bit more interesting to you all. So under substantive law, you have things called mala in se and mala prohibita, and these are Latin terms. Mala in se means bad in and of itself, and mala prohibita means it's bad because it's prohibited, or bad because we say so. And this gets at the idea that mala in se is saying that some acts are just bad in and of themselves, like murder, rape, robbery, things like that. And then some things are just bad because they're prohibited. There's a law against them. So, like, I don't know, possession of marijuana, or speeding, or driving without your emissions inspection completed, or running a red light, or something like that. These minor, prostitution. A lot of these things you'll see if you think about the different victimless crimes in the world. A lot of these involve drug offenses and things like that. And so there's also some limitations to criminal law. One being the overbreadth doctrine, which means that laws are unnecessarily broad. They should be narrow enough to be able to control the behavior that they're trying to do without just saying, something that's overly broad. You don't see that too often because, they're usually pretty clear about this. One thing that you'll probably, and you can make this argument about a lot of things because the way laws are written are often weird and kind of vague. And at least it may not even be vague, but it's difficult to interpret exactly what they mean sometimes. And I was just talking to a judge about this law about concealed weapons permits. And the way that it had always been interpreted, I actually told her, well, that's not the way I see it, and it looks like, well, you look at all these other things, and she's like, oh, wow. So there's a bunch of people that have been denied concealed weapons permits in Cobb County for quite some time when they probably could have gotten them. But anyway, but the void for vagueness doctrine means that you can't write a law that is so vague that we can't understand it, or that it has no meaning. And so one of the things to do so is actually unconstitutional. And one of the big things that we've seen in recent years has been laws being overturned as unconstitutional, such as noise ordinances. I know back when I lived in Virginia, there was a noise ordinance that was overturned, and it was deemed to be unconstitutional at the state level by the state Supreme Court, because it just said you're not supposed to be unnecessarily loud or something like that, but it didn't actually define what loud was. It was vague. I mean, if I'm mowing my grass, is that considered loud? Or how high do I have to turn up the music at my party before it violates this law? And so they didn't specify that. And so then the Supreme Court in Virginia said that, that was too vague, that if they wanted to be able to keep that law on the books, they're going to have to be more specific for what means or what constitutes loud music or a nuisance type of thing like that when it comes to that statute. So that's a good example of that one, at least. And so there are different elements to criminal law when you're trying to prove someone guilty of a criminal offense. The first thing is called corpus delicti. And corpus delicti literally means the body of the crime. So in most of the time, you will consider the body of the crime to be, in a murder case, you would say, hey, the body of the crime is the body of the person that was killed, right? And in many cases, that is the case. You have to actually prove that someone was killed. And this is why, really a lot of organized crime organizations and stuff will try to dispose of the body, and any kind of intelligent criminal, I suppose, would try to dispose of the body as best that they could, so that way the state can't prove that this person is dead. Because then what happens is the person is listed as a missing person, and there's tons of missing people in this country. And you know what happens is the person is listed as a missing person, then there's no criminal investigation, there's no murder investigation, because the person is considered to be missing. And then, even if there is an investigation, if you can't prove that the person is dead, then you can't prove that someone else killed them. It is possible to actually prove the body of the crime, so to speak, in a murder case without the actual body. Like if you had a scene where there was just so much of this victim's blood everywhere that you could maybe have an expert to testify to say, well, this person lost so much blood, and there's so much of this person's blood everywhere that there's no way that they could have possibly biologically survived after having lost that much blood. So that's a way of doing it. But this is just using murder as an example. It applies to every crime. If there was, a robbery, if there was, if someone drove without a license, well, one of the things that you'd have to prove if someone's driving without a license is not only did they not have a license, not having a license is a pretty easy part to prove, but you have to prove that they actually drove too, right? And that they drove without that license. And this gets at the idea of actus reus and mens rea too. And so actus reus is just the act, that you committed the act of the crime. So, if you murdered someone, you actually shot them and killed them. Mens rea is your mental status, your intent, that you had, that you had intent to do so, to some extent. Now, intent is on this continuum here, which shows strict liability, negligence, recklessness, knowledge, purpose, and so there's different levels of intent. Under strict liability, they don't have to prove any actual intent. It's just strict liability to say you did the act, so therefore you're strictly liable for it. And so most of the time you'll see things like this when you see like speeding or running a red light or something like that. When you go to try to convict someone of speeding, you don't have to prove that they meant to speed. All you had to do is prove that they sped. So you violated the speed limit. I don't have to prove that you did it intentionally. I just have to prove that you were driving at 85 in a 25 mile an hour zone. I don't have to prove this mental factor that maybe your speedometer was saying that you're going 25. All I have to do is prove that you did it. And then negligence is a little bit more than that, to say that you should have known better, but you did the activity anyway. And then recklessness is, you did it with wanton disregard for human life, for property, and things like that. And then knowledge and obviously purpose is what we really think of when we think about intent, right? You did something on purpose. Another part of intent that you'll see very specific to first-degree murder cases is this thing called malice of forethought, meaning that you kind of had this premeditated notion that you wanted to go and kill someone. You had this forethought of bad intent before you actually went to do it. So that's one of the elements that they have to prove for that. Another interesting idea of mens rea is for burglary. Burglary is known as something that requires specific intent. So not only did you break into this house, but you did so with the intent of doing something else once you broke into the house, like committing a felony or stealing property or committing an assault, something like that. So not only did you just break into the house or burglarize this house, but you did so with the intent of doing something else in addition once you got in there. And so there has to actually be concurrence between the actus rea and the mens rea when the offense is committed. And so there's an interesting case that I'll tell you guys about. And there's a funny story about how an example of this might happen, where there's not concurrence. Actually, I can give you a couple examples now that I think about it. The most interesting one, I guess, is this idea that, all right, so this guy has left his wallet on the counter somewhere. He's been paying for whatever at some gas station or something like that. Or maybe he's at a friend's house and maybe he leaves his wallet sitting on the counter table or the counter, coffee table, whatever. So then he picks up the wallet and takes it home. And this is it. He thinks it's his wallet at the time that he picks it up. Now he finds out later that this wallet is actually not his when he goes and opens it up and realizes it's someone else's wallet. And if you think about this, at the time he took that wallet, he committed the actus reus of theft, of stealing someone's wallet, right? But at the time that he did it, he didn't have the mens rea of stealing someone else's wallet. He didn't have the intent to steal someone else's wallet. He didn't have the knowledge, he didn't have the purpose of doing so. He thought he was taking his own wallet. So these two things did not happen at the same time. There wasn't concurrence. Now, then the question becomes, if he keeps the wallet after the fact, so suppose he doesn't return the wallet, well, it's still not theft. He might have developed that mens rea, or that intent, to keep the wallet after he took it, but they still did not occur at the same time. There would still not be concurrence. And this would be an interesting argument to make to a jury. I wonder if they would buy it, but judges have in the past, because as a legal fact, this is actually very true, that these things did not concur. And there was no concurrence, and so therefore the person would have to be let go. Another example would be another larceny issue where maybe you had a banker or someone who you gave money to invest, and so they're supposed to be taking care of your finances. Maybe they're an accountant or banker, investment banker, something like that. And so you give them your money to do whatever with, to invest, to purchase a house, to do whatever, and rather than them doing what you wanted them to do with the money, they decide to deposit it into their own account. Well, that's another issue of concurrence. When they took the money from you and you gave them the money, they didn't have the mens rea to keep it for themselves, but then they chose to do so later. And so they got possession of this money by legal means, but then they later converted it to their own. And so this was a loophole in criminal law for quite some time, until states started passing statutes for embezzlement. And embezzlement filled that little gap in the loophole there, where they said, okay, well, just because you came into possession of this person's funds legally doesn't mean that you can still go and do whatever you want with them later on, because you didn't manifest that intent at the time that you came into possession of them. So embezzlement statutes fill that void in there. I went on with that a little bit longer than I intended to, but hey. So some other types of offenses that are kind of interesting to think about are these things called inchoate offenses. And these are things related to attempt, solicitation, and conspiracy. So they can charge you you've probably heard of people being charged for attempted murder, or solicitation of prostitution, or conspiracy to commit murder. These things don't actually require that you actually commit the offense. You just have to have attempted to do so, or solicited, or conspired. And so you might ask, well, how does this concur with the mens rea and actus reus? How does the act actually have concurrence with the intent? Well, when you attempt to do something, suppose you attempt to kill someone, you're charged with attempted murder, but they don't die. Well, you still manifested the intent to kill them, and you still had the act where you shot this person, right? You shot them, so there's the actus reus, and you had the intent, so there is still concurrence. So the fact that they did not die doesn't mean that you should be let go. The big one with solicitation is, soliciting a prostitute and things like that. You had the intent to pay this person to have sex with you or whatever, and then you solicited them, you offered them money in exchange for it, so you had an act. Then the act was the actual solicitation. It wasn't the carrying out of the offense. And then conspiracy is another one too, and so you probably hear, there's a funny, not really funny, but there's a crazy story recently in the news. There was a guy that wanted to have his wife killed, and the idiot ended up trying to get undercover police officer to be the hitman to do this. And so he was actually convicted of conspiracy to commit murder because he had conspired with this detective who he thought was a hitman to be able to murder his wife, and so he was sent away for conspiracy to commit murder. And so that's just one example of that. So if you have an agreement between someone else to commit a crime, regardless of whether you guys attempt to commit the crime or not, you've still conspired to do it. So maybe you have a plan with a couple of other people to rob a bank. Well, if you guys, talk about it and develop a plan to do it and agree to do it, you've conspired to rob a bank. And so that would be, you could be found guilty of conspiracy to rob a bank or conspiracy to commit murder, things like that. So there are different defenses to violations of the criminal law, and so these things end up being decided in courts as well. And so the things with defenses, they are known as affirmative defenses, which means that you bear some burdens of proving these things. Now, because the defendant can never have the burden of proof in a criminal trial lies with the prosecution. You do have what is known as the burden of production and the burden of persuasion. That means that you have a burden of producing some evidence through the burden of production, burden to produce some evidence that supports, your story, and the burden of persuasion, which is the burden of persuading the jury or the judge that this is what actually occurred. And so one defense might be an alibi. So you want to have an alibi that you're accused of murdering your wife, but it turns out that your wife was in Georgia and you were out of town at a conference in California for that entire week. So there's no way you could have committed that offense. And of course you want to have people who can vouch for the fact that you were there. You probably want plane tickets, hotel bills and different things like that to help, prove this, because the jury's not just going to take your word for it. And so an alibi, I would say that I did not commit the crime. And then there's things called justifications and excuse defenses. These are also affirmative defenses, but these things argue that you did commit the offense, but you were either justified in doing so or you should be excused from doing so. So in a justification offense, you guys have probably heard of self-defense, right? So if someone's about to kill you or shoot you or something, then you're then justified in defending yourself, and so then you did actually commit the offense of murder by killing this person, but it was justified by self-defense. And of course, you bear the burden of proving or producing evidence to show this and persuading people that this is actually the way it happens. And so some states have something called the retreat doctrine, to where if someone's about to kill you, then you are required to retreat and try to run away. And it's only once you're cornered and you have no other alternative that you can then use self-defense. Georgia is not one of those states. And then there's also something called the Castle Doctrine. And Georgia is one of those states too, which says the Castle Doctrine is based on this idea that your home is your castle. And so you get to defend your home. And so then the retreat doctrine does not apply when you're in your home, if it's a state that abides by the Castle Doctrine. So the Castle Doctrine says that if someone is trying to break into your house, you are allowed to use lethal force against them. And in other states that don't have the Castle Doctrine, you would have to prove not only were they breaking into your house, but that they posed some sort of imminent threat to your life, so that they were breaking in and they were about to shoot and kill you. And so that's a little bit more difficult to prove, rather than this person kicked in my front door and I shot them. And so in a state with the Castle Doctrine, you would be justified in shooting someone who simply kicked in your front door. You don't have to prove that they had the intent to come in and murder you. You just have to prove that they kicked in the front door. I would imagine that this works as a good deterrent from people from breaking into people's houses, because they know that if they break in there and the people have a gun, then they're legally allowed to shoot them. So the other justification would be consent. And you're saying, well, this is kind of weird. How people can have consent? Yeah. And so there's very few offenses that this applies to, but you can think about assault. So every time somebody goes on a football field, they're probably assaulted. They're hit and beat up and, pushed around and tackled and all sorts of other things. Or if you think about martial arts tournaments and things like that, when you go and you engage in a martial arts tournament, you're consenting to this person hitting you, even though in doing so, that person is assaulting you and assault and battering you because they're actually making contact. However, that person has consented to that. And so then therefore you're justified in doing this. One of the big things too is, when it comes to statutory rape cases, people will try to make the argument, well, I was 19 and I had sex with this person who was, 17, and yes, they were under the age, but they consented. It wasn't non-consensual, it was consent. However, consent does not work with that because in order to give consent, you have to actually be over 18. So that's one little way that they get people with that, which doesn't actually work for them. So there's just a few examples of justifications and stuff like that, and we'll talk a little bit more about that as we move on with the class. Like I said, this is mainly just a review. And then you'll have your excuses. And so these are a little bit different. And they usually involve age. So, under common law, it's if somebody's less than 7 years old, then they should not be able to be convicted of a criminal offense because, when it comes to this mental intent element, can you really say that a 5-year-old manifested the criminal intent to actually kill someone? And there have been cases where 5-year-olds have, been playing with a gun or whatever and found it around the house and shot someone and possibly even killed them. But did the 5-year-old really intend to kill them, or were they just playing with something that they found laying around the house? So, that would be an excuse to say, well, this goes to the mental intent. And then another one is insanity, right? So was this person, were they capable of manifesting that mental intent to commit this offense? Do they really understand what they were doing? And so these would be things that are obviously something that someone's defense attorney is going to have to prove and produce evidence and persuade people that this is actually the case in court. So we'll talk more about that later on in life. So one of the big things that I think is good to remember that there's some differences between civil and criminal law, and your book has a little bit more details about that. So I won't go into all of those details for our purposes. But when you think about the burden of proof, they're very different between civil courts and criminal courts. In criminal court, the prosecution bears the burden of proving their case beyond all reasonable doubt, which means that there's not any reasonable doubts, obviously. No reasonable person would doubt that you're guilty of this offense. However, in a civil matter, in civil court, the burden of proof is only a preponderance of evidence, which means that it only means that the plaintiff has to prove that it's more likely than not that their argument is valid. It's more likely than not that you actually did whatever, you were negligent and you hit them with your car or whatever it is that the case is about. So the burden of proof is much less. And the example that I like to give when I talk about this is the O.J. Simpson case. So O.J. Simpson was acquitted in criminal court, remember, and you guys can go and watch, I think HBO or Netflix or someone's got a story about him. You can actually go and watch all of the trial videos, because California allows the videos taping of the trials, and you can see Johnny Cochran giving closing arguments and stuff like that, which is really cool. I did that back when I was in undergrad, and it was kind of neat to watch him with the glove doesn't fit, must have quit. But anyway, so OJ got off in the criminal trial because the burden of proof was beyond a reasonable doubt. But then what happened was he actually got found guilty of wrongful death because he was sued in civil court for wrongful death, and so then he was found guilty of that by a preponderance of evidence. Now that didn't send him to prison. He went to prison for something else unrelated, I believe. But anyway, I think he was trying to steal some of his art back, or he was stealing some art from somebody or some stuff, or sports memorabilia. but he said it was his, but then he was taking it from somebody. I don't know. Anyway, that was unrelated to this case. But anyway, he was found guilty of wrongful death and had to pay the family of his former wife, the person he was accused of killing, a lot of money because he was found guilty of wrongful death in that wrongful death civil suit in the civil court, where the preponderance of evidence was the burden of proof, and so it was much easier to meet that burden of proof than it was to meet the beyond a reasonable doubt burden of proof. So with that, I think that is all I had to kind of go over with you all today. So I look forward to talking with you all next week and reading your discussions, and don't forget to do discussion boards and take your quiz and all that good stuff. And with that, I will say goodbye and wish you all a good week.